Welcome to TechTrends. TechTrends is a podcast series that provides a perspective on the latest trends in technology, fintech, and digital. On today's episode, we'll talk about intellectual property, what it is, why it's important to protect it, and what methods are available for you to protect your intellectual property. I'm Anish Bhimani, Chief Product Officer for Commercial Banking, and joining me today is Daryl Wooldridge, Global Head of Intellectual Property here at JPMorgan Chase. Daryl, welcome to TechTrends.
Hi, Anish. Thanks, and it's great to be here.
So, Daryl, innovation starts with good ideas, and protecting ideas or intellectual property is crucial to bringing innovation to market, right? But intellectual property means a lot of different things to a lot of different people and can cover many areas, and there's different kinds of protections. Can you help us demystify all of this? Like, what is intellectual property, and what are the methods that businesses have to safeguard it?
Yeah, Anish, in thinking about what intellectual property is, at the most general terms, it's human intellect. It's the creativity, innovation, knowledge, know-how that comes from people. But really what we're talking about is how do you protect that? What are the protections that are available? That's copyright, trademark, trade secret, and patents. So let me give a little bit of a definition of those, give a little bit of background, and help people kind of level set from there. There's three of those that are public. Patents are very public. In exchange for disclosing your idea publicly, and allowing other people to understand that innovation and perhaps further innovate off of that, you get a guarantee from the government for 20 years of exclusivity. And so that's really valuable to a firm. If you think about if your product and service now has a 20-year protection associated with it, where you can prevent others from using, making, offering for sale your ideas, that can be very valuable for you. There are trademarks. In the terms of JPMorgan Chase, you can think about our brand and how important that is to us. Any dilution of that brand, anything that confuses customers in the marketplace can be very damaging to what we're trying to accomplish. That's true for all companies, though. And so really protecting the brand and that trademark, which can be the name, the logo, a phrase. So it's not just our corporate brands, but also if you think about some of the taglines and some of the things associated with some of our marketing becomes very important for us. Copyright exists upon creation. This is the one where there are actual rights without having to register or do anything else. As soon as you create that work, you have some protection in place. You also have, if you think of it in the terms of novels or works of art that people understand, that makes a lot of sense. You'll hear it sometimes referred to, or you referenced when we think about code. And we don't copyright code, register copyright code, because it changes frequently. That's not one that we utilize heavily because there are some protections that exist just upon creation. Trade secrets, and that's probably, it's a secret, right? So that's one of the most difficult ones to understand. But these are things that you don't want to publicly disclose. You don't want to have out in the marketplace. These are algorithms associated with some of our fraud detection, things like that are very important to us as a firm. But we want to make sure that those aren't exposed, can't be used by somebody else. And so we have certain steps that we take to protect those things as well. For trade secrets, it's much more about controlled access, limited access, need to know, auditability of that. And that's what helps to keep that protected and gives you some recourse if that is disclosed by any of your employees. So those are kind of the four main areas of intellectual property. They're utilized in different ways. I'll kind of wrap it up in one example for you that maybe people would understand. That's in a credit card. So you think about a small credit card and you think about what intellectual property rights are associated to that credit card. It's actually all of them. So you have patents, utility and design both, utility on how it functions, maybe on the RFID technology, Bluetooth low energy, different things like that are incorporated into the card. You have design. What does it look like? What does it feel like? Is it a vertical card? Is it a horizontal card? All those different things go into play in that space. You have trademark, clearly our brand, whatever our brand is, potentially a partner brand, and other things on the card itself. And you have the trade secret associated with some of the things that happen behind that, around how we detect fraud, how we do other things in that space. And then lastly, copyright in the terms and conditions. So you can actually have a small product that has all the different types of intellectual property that we talked about, all incorporated and all helping to protect the value of that product.
So patents, copyrights, trademarks are public, as you said. Trade secrets are not. So for a trade secret, it's not something that you actually protect publicly. It's just something you just decide we're going to protect this much more ourselves and not let people know about it. Is that it?
That's right, Anish. Trade secrets, again, are fully handled internally, and you take the right measures and steps to protect that through your own process, not through a government process.
Let's talk about what it means to protect these things or to go through all of that process around that. Right. So IP are some of our most significant company assets, right? And can be have a ton of value, set us apart from competitors, drive revenue, et cetera. How do we identify, first off, find it, and then keep intellectual property safe at a firm the size and scale of JPMorgan Chase?
Yeah, it's interesting that you bring up the size and scale and how that affects our intellectual property protection. Because it's important for small companies or large companies. Certainly, our situation is a little bit more complex, multiple lines of business, tech, ops, and business around the globe, which makes it a little more challenging. But some of the things that we do as a large firm also apply to smaller firms. So I'll start with how we do things. One of the ways that we find intellectual property rights associated with our innovation is through a team of strategists that sit in technology. So if most people think about intellectual property, they're probably thinking of IP attorneys, a purely legal function. We have IP attorneys, but we also have an IP strategy team that sits embedded in technology in our product development teams. And what we do there is look at what's on the roadmap. What types of things are we developing? How can we make sure that we protect that investment that's happening there? We look at the investment initiatives over the 1, 3, 5 year type of time frames. So we're looking at Horizon 1, 2, and 3 opportunities. We're looking for in the immediate. Is there something that we're doing that is innovative enough and we think is market differentiating enough that we want to have that competitive advantage? We want to sustain that through having the underlying IP rights. We have 2 different ways we do that. So one is through awareness and making sure that our technologists as well as our product and business people know how and where to submit invention disclosures. But I think a lot of people get wrapped up on it. They hear invention disclosure and they're thinking, wow, that must be the Edison light bulb moment, that thing we all think of like that. It's really not. It's really incremental innovation. It also addresses people who think, if I thought of this, anybody could have thought of this. They don't think that it's that innovative because they're really smart and really highly skilled in their space. But what we talk about, and I try to boil it down to the most simple thing, I take all the legalese out of it, and we talk about, is it new? Is it something that's not in the marketplace today? You as a subject matter expert would know if it's in the marketplace. If it's not there, then that's something that's potentially innovative. Is it a difficult problem to solve? And then there's kind of a cool factor. Is it something that's a little bit unique, kind of cool, something that you think that you would brag about to your other technology friends? Then that's probably something that's pretty interesting to us. And what we try to do then is take those ideas in, whether they come into us passively or that they come into us actively by going out and mining and talking to our most innovative groups and say, okay, is what you're doing today patentable? If it is, that's great. That's something that we should protect. But then starting that conversation with a lot of questions around what if? What if you didn't have a time constraint? What if you didn't have limited resources? What if you had more dollars to put in this? What does version 3.0 or 7.0 or 5 or 10 years out from now look like? That becomes a much more interesting conversation when you think about it from an intellectual property perspective. Yes, you want to protect your products in the marketplace, but you want to protect your future products as well. And that's really one of the ways that we go after that.
So as you said, Daryl, ideas can come from anywhere, right? I had an idea patented 18 years ago. I have a few years left on that patent, right? And what I remember is that I thought the process was going to be overly cumbersome and daunting and other things like that. And it was definitely work, but it wasn't really as complex as I thought it was going to be, at least from my end. Can you talk about that process? I think a lot of people are somewhat intimidated by, you know what, I shouldn't bother. It's not that big of a deal. It's going to be a huge pain. What does that process look like?
Yeah, that's a great point, Anish, in thinking about what the process is for getting patents. It's really a lot less complicated than most people think it is. A lot of people, again, think that bar to entry is much higher than it is. They also think that they're going to have to create a bunch of specialized documents. But again, that's where you have people who are available to you either internally or if you're a smaller company, externally. We even use outside counsel to do a lot of our drafting. And really, it's as simple as, do you have the problem, the solution statement, and can you help us creatively think about maybe 2 or 3 other solutions that you're not implementing, but might also have value to them? And if you can do those things, it doesn't require a whole new set of documents. If you have architecture diagrams, if you have executive summaries, if you have workflows, things like that are very valuable to the intellectual property attorneys to be able to turn your idea into a patent application. But again, it's as simple as, do you understand the problem? Do you think you have a unique solution? Are we able to then go ahead and get those rights? It doesn't require a ton of extra work. And internally, we've reduced that to a 15-minute invention disclosure form. We have about 2 hours of time spread out over 6 to 8 weeks that's required. So there is a time commitment to review the draft, make edits, that type of thing, make sure the attorneys have really captured the essence of your innovation. And then the work is really out of your hands, and it goes to the patent office, and there are a number of things that happen from there. But really, it's a fairly simple process. It shouldn't be limiting. People should not be afraid to submit the ideas. I can tell you, people who work in my space, the worst thing that's going to happen to you, you're going to have a conversation with somebody who's really interested in innovation, who's excited about what you did. And at the end of the day, we say, you know what, it doesn't meet the threshold for patentability. It's still a great idea, and you will understand more about the process, and you'll have the opportunity to then try to bring another idea forward in the future.
So what I'm hearing is, if you're not sure, ask, right? Sort of lean in towards starting the process. Worst thing, you decide, it doesn't make sense, but ask rather than don't.
Exactly, and ask early and get the ideas in early. In the patent space in particular, it's incredibly important first to file. So if you think you have something, even if it's not fully baked out yet, get that idea and talk to somebody about it. Again, if you're a small company, talk about it internally, maybe engage your counsel and think about what you can do there.
So that's a good point. So look, the core of our IP are the ideas, and they come from employees, right? What is it that drives so many employees to apply for patents? What are the benefits that accrue either to the company or to the person of protecting their IP?
If you think about protecting IP and the value back to the individual for contributing that, it's really, it's differentiating. We talk about market differentiation for the products and services that the underlying IP protects, but it differentiates you as an individual. There are a lot of people who do your job. There are a lot of people in a company our size. There are a lot of software engineers. What makes you different? How do you stand out? How do you show that you're different than the other 30,000 people sitting next to you, or if you're in a small company, the 2 people sitting next to you? One of the ways you do that, it's not really about the patent. It's about proving and showing that you have innovative problem-solving skills. And that's evidenced by patents, but that's not the end game. The end game is for you to come across as an innovative person. You can do that by filing patents. You can demonstrate that. You have the ability then to market yourself internally for mobility opportunities, externally, a number of different things that set you apart.
And I know something that you've always been very passionate about, and we've started doing a number of years ago, is an annual inventors recognition sort of dinner ceremony sort of thing. And I've been to a few of those, and it's great to hear the ideas and even just the combustion that goes on among the tables of all the people about sharing the different ideas they have. It's somewhat infectious. So that's great in terms of the value for the individual. How about for the company?
Well, when you think about patent value for a company, there's a number of different ways. So as JPMorgan Chase, our general philosophy around this is we want freedom to operate. We want to be able to continue to offer our products and services uninterrupted to our customers. The worst case scenario for us is we build something, we don't secure the underlying intellectual property rights, and then somebody else gets rights in that space and prevents us from continuing to operate our business the way we want to. So that's the first and foremost for us, absolute most valuable piece of what we do. Secondly is partnerships. So again, it's not about preventing innovation. It's not about preventing others and getting patents and locking them away and keeping others from doing things. If we own the rights, it makes us a much better partner when we go out and we think about our different companies that we can work with, that we may want to co-develop products with. If we can guarantee and give them a sense that we have that ownership, then that's really important for that relationship. Those are kind of the 2 main ways that we see getting value from intellectual property rights. There are many others. There's licensing, there's revenue income. Sometimes we make vendor products better, and then we can give them the intellectual property rights or license that to them so they can improve their products for other people. Even in the sense of securing our rights to do things that are good for the world. And so we recently joined the Low Carbon Patent Pledge, where we pledged some patents around how we cool our data centers. And you can imagine that in the data centers, that is the cost, and that's also the impact to the environment, is how much energy we have to take to cool those data centers. And so we wanted to make that freely available. So through the Low Carbon Patent Pledge, we're able to put our patents into that. Other people can freely use that patented technology and solution, and it perhaps further impact their data centers, and have an even greater impact on our environment.
That's great. Now, it's no secret that technology and innovation has exploded over the last number of years and continues to grow exponentially. Right, technology is radically transforming the way we do business, whether it be the products we offer, whether it be our internal processes or how we offer things to clients, our internal work process for employees. What impact has that had on the pace and our approach to protecting intellectual property? I mean, we've filed hundreds of thousands of patents over the years, right? Do you see that picking up? Does it change the way we think about it? How does that work?
The change of innovation directly affects how much innovation we're looking to protect. We have seen an explosion in the number of filings in the U.S. and around the world, not for us, and not just for us, but for all companies. And I think that's a real recognition of the value of having those rights secured and being able to do the things you want to with them. I think that for us, what I've seen the most is there's a significant amount of get it done quickly. The innovation is changing quickly. Mm-hmm. You need to, we may file a patent today, but to your point, you have a patent from 18 years ago. I have no idea if that technology or what you did is still applicable today. Mm-hmm. Chances are it's not. Chances are a patent I filed yesterday won't be applicable 3 weeks or 3 years from now, certainly. So what's the value in getting that 20-year protection in a rapidly changing technology space? In really the value, again, is back into those conversations around what does version 3.0, 7.0 look like? Are we able to envision multiple different ways of doing something? Are we able to do a family of patents? And so that's really changed our strategy. You used to maybe file one patent on one aspect of what you were doing. Now we're looking to file multiple patents within the same family that help us to figure out where the technology may grow to, where it may go, gives us the opportunity to add to that in the future. And so those are things that strategically we have to think very carefully about. And also, if it's something that is not core to our company, not a real competitive advantage, is it something that we really want to patent protect? Just because we can doesn't mean we should. And so if we feel like we're still going to have our freedom to operate, if we have good established good prior art in the marketplace, meaning that, have we established that we have done this, that we've done it publicly, giving us some defensive rights there, then it's, that might be the pathway. So it's really, although we're seeing more patents, we're also making a decision not to file as many patents in certain spaces based on that rate of change.
So that's a good point. I think a lot of people might sort of buy into that argument that, hey, wait a minute, by the time the patent gets granted, the technology is going to be obsolete or other things like that. On the flip side, and this is always a challenging topic, you see a lot of people that file these very broad patents and then make all their money suing other people for infringement of patents. And it sounds like one defense you might have is, look, if you register that we were doing this work on a certain day, can give you a broader defense against some of those less than savory folks that are trying to do a lot of that, right?
Certainly non-practicing entities, as we refer to them in this world, are a difficult problem, right? So these are companies that acquire patents that don't actually produce anything. They're not operating companies. They don't manufacture. They don't create jobs. They simply collect patents and then try to impose a tax on other people. And so that's certainly a scourge. And there are a number of ways that we try to address that. We, again, publish things. That's one way. We get patents ourselves. We also look at joining other companies in how to solve this problem. So we don't believe it's just a public problem that the government should solve all these woes. There are private solutions to these as well. One of those is the License on Transfer Network, which we're a member of. And what we've done there is come together with a large number of technology companies, automotive, semiconductor, across all industries, financial services, obviously, a number of different industries. And these are companies that said, you know what, we want to compete on products, services, and our employees and what we're able to give to our customers. We still want to retain all the traditional rights of intellectual property. Again, if we have an issue with an operating company, we can still enforce our patent if they've stolen our ideas, that sort of thing. But in the event that any of us sell our patents to non-practicing entities, it triggers a license for everybody else who's a member of this organization. And it says, so it protects us from being sued by these other companies that are part of Lot Network, any other patents when they end up in those hands of I think, as you said, people who intend to do harm. And that's really an important aspect of what we think about. And that's open to all companies. That's small startups, that's large financial services companies, again, across all industries. And it can provide a lot of protection, not just for a company like JPMorgan Chase, but also if you think about a small startup that doesn't necessarily have a patent portfolio of their own, may not have some of the defenses in place, may not have some of the resources to file as many patents. They can join some of these consortiums and opportunities like this to help eliminate some of their risk from the marketplace. And really, for me, if I can help mitigate risk, that's a fantastic thing for our firm.
That's great. That sounds like a great solution actually to a difficult problem. So, one other thing, how would you reconcile? Obviously, for the last number of decades, actually, we've had a huge push towards open source, especially in software development, right? And how do you reconcile the desire to do more open source development and consume more open source with the need to protect your intellectual property?
Yeah, I love this open source versus patents kind of question. It comes up, all the time when we're having conversations with our software engineers. And in talk about rate of change, it used to come up occasionally. Now it comes up all the time. Everybody who enters, out of our software engineering program and other things, this is a hot topic because people do want to be able to contribute to open source. They want to be able to use open source. Let me just start with, they are not mutually exclusive. Patents and open source are not mutually exclusive. They coexist. They're actually very complementary to each other. There are a number of companies, including ours, that do both. And the reason we do that is even if I protect the intellectual property rights, I can still contribute that intellectual property to open source. There's nothing that prevents that. I'm going to grant a license to the open source community based on their terms and conditions and licenses that would include the underlying intellectual property rights. And honestly, it should give that community, again, a more stable sense that what I'm contributing is actually mine to contribute to begin with. So I see it as a benefit when you're doing those types of things. I want intellectual property rights because I want to have control over the destiny of our innovation, of the value of the investment we've made in those ideas. That once we have that secured, we can donate, contribute, give away, license, keep, any number of options. But if we don't secure the rights to begin with, we've lost the control of those options.
It gives you optionality. That's a great way to think about it. So we've talked a lot about the benefits of IP protection. What are some of the risks or disadvantages to doing it?
The risks really are only the financial risk, right? You're investing in things that might not ultimately have value. If you think about patents, you may file 10 patents. One of those is incredibly valuable. 9 may not be. And so there's not a risk to the firm from a reputational perspective, from from gaining those rights, but there is a cost. And again, with a company like JPMorgan, all the way down to a very small company, you have to weigh that risk-reward benefit. And so I think that's really the risk with taking a comprehensive approach is only in deciding, are you potentially detracting dollars or time or energy away from something that is more important to the mission of your firm? And again, in a company that's large, it's part of it's just part of the culture. It's part of the things that should happen. In a smaller company, those are difficult decisions that have to be made. But I will say too, depending on what you're doing, depending on how early into the marketplace you are, how close to product you are, what competitive landscape looks like, it's still something that small companies need to really carefully consider. But again, instead of a family of patents, maybe it's getting that one patent on a really core key component of what you're doing to limit your total cost, but yet get you the protection that you need.
Yeah, I mean, really, so it's just the work and the cost of going through the process, right? It's almost like, you almost think of it as like insurance, right? Something like that in a sense, right? So as you mentioned, companies large and small, whether they be a startup or a 300,000 person global bank, can benefit from IP protection. But not every company has the size and scale of a JPMorgan Chase and doesn't have a division around intellectual property or even a person focused on intellectual property. What can they do? You've built up a wonderful world-class function over the years. What about somebody that's just getting starting, doesn't know where to start? How do they go about protecting their IP?
IP protection for companies that don't have an internal team can be very easy to accomplish. There are a number of law firms that can provide those services. We actually utilize like I mentioned, we have an internal IP strategy team. We have an IP legal group of IP attorneys that work together. That makes up the internal part of JPMorgan. But we also engage outside counsel still and have them do a number of things for us. So if you're a small company, if you have a general counsel, or even if you don't have a general counsel, you're two people in a garage with an idea, there are still things that you can do. And the U.S. Patent and Trademark Office has a number of low-cost options for individual inventors. So not companies, or again, small startup companies, as defined again within their parameters. That makes it available and less expensive for you to still seek the same protections that a large company like JPMorgan Chase can have. So it's open and available to everyone. The costs vary based on whether you are doing an individual filing, if you're doing it as a company, if you're going through a law firm. So there are different paths and avenues. Don't stop before you explore. So make sure that that you've actually thought through, you've explored some of your options, you've determined what the cost is, and then really, again, weigh that cost against, if I'm going to spend these $10 here, am I going to gain enough for doing that, or should I be spending the $10 doing something different? And again, $10 is just representative. Obviously, it's significantly more expensive to file a patent, but there are low-cost options. There are ways to do that. Especially the Patent and Trademark Office has special programs available for different people to be able to do that.
Okay, great. Daryl, you've been doing this a long time, right? And you've seen the space evolve over the years, right? If you were to flash forward 3 to 5 years with the pace of innovation, obviously in technology, but also just the way the space of IP protection is evolving, where do you see this going? What does this field look like 3 to 5 years from now?
Yeah, I think the way the IP field is changing, and it really relates to a lot of the things that we're seeing in different technology spaces everywhere and in business practices. We're starting, we've already been using machine language learning and different things like that to make sure that we are able to understand, how big data sets, where there are commonalities. It used to be a few people sitting together and talking about what patent applications they saw or invention disclosures from different lines of business and trying to connect those threads. Now we have machines that can do that for us. They can find those common patterns, even if it's not the same set of words, things like that. That's incredibly valuable to us. So we've seen our business model shift in utilizing that. Artificial intelligence is kind of the next step. And do we have the ability then to help further our innovation by supplementing that through artificial intelligence, AR, VR? Are there ways that we can do that to help our inventors think to that Horizon 3 step? So those are things that we're exploring. I think that will change how we do our business going forward. And then he was talking about AI. It raises an interesting question that's currently discussed in my circles, which is, again, we talked about intellectual property is human intellect. Mm-hmm. So if the AI machine or if the AI function develops something, is it patentable or not? And that's something that's currently being discussed and decided because it's not human intellect at that point. And by definition, that's what's required. So it'll be interesting to see how that affects things, if those things are patentable or not. But again, a number of ways we can apply technologies that you all are using in your businesses to what we're doing as well, and making sure that we understand the competitive landscape better, that we make sure that we find better partners earlier, those opportunities like that.
Yeah, my head hurts just thinking about AI generating patents for other AI things like that too. But it's fascinating. Well, it'll be interesting to see how the space evolves. Daryl, thanks very much for joining us today and for sharing your thoughts on this fascinating and insightful topic.
Thanks, Anish.
And to all of our listeners, if you enjoyed this episode, remember to rate us and subscribe on Apple Podcasts, Spotify, or wherever you listen. Tune in next time.